All rise. The Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable Richard P. Warfinger, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated. Good morning and welcome to an oral argument session of the 5th District Court of Appeal. As the Marshal indicated, I'm Judge Orfinger, and I'm joined on the panel today by Judge Rand Wallace on my right and Judge James Edwards on my left. We have a full docket today because we have some add-on cases, and because of the holiday week next week, we have an afternoon panel as well. So we probably will only take one short break in the middle, probably about 3 cases in, and I don't think we're going to have time for coffee with the attorneys today, which I deeply regret. But we've got to try to get finished before the afternoon panel starts at 1:30. If you have anything that makes noise, such as a cell phone, we'd appreciate it if you'd silence it so that you don't interrupt the parties. Let's see, I think we have all civil cases, no, one criminal case. The civil cases get 20 minutes per side, and the appellant can reserve as much time as he or she chooses. Just let me know. When the clock flashes orange, you're into your rebuttal time. The criminal case has 15 minutes per side, and likewise, the appellant can reserve as much time as he or she chooses. Just let me know. With that, we'll go ahead and call the first case, State Farm versus ALISON SWANSON. Morning.
May it please the court? I would like to reserve 5 minutes.
Yes,
sir. Your Honors, the issue in this case is whether a trial court's order granting a new trial should be reversed where the factual basis set forth in the order is incorrect, where the factual basis set forth in the order is objectively incorrect based upon a review of the record. Respectfully, Your Honors, this is a simple case. If the facts set forth in the order for new trial are wrong, then this court should reverse. The Supreme Court set forth a very important rule in Lasky versus Smith, and that is that a trial judge is not permitted to act as a 7th juror with veto power. His setting aside of a verdict must be supported by the record or by findings reasonably amenable to judicial review. And that statement of the law is throughout the cases that are cited in the briefs, that the setting aside of a verdict must be supported by a record. So to grant a motion for mistrial, there must be support in the record for the trial court's findings.
Mr. Goebel, the standard for granting of a mistrial is higher, I guess incrementally higher than the standard of abuse of discretion. Is that correct? Because there was a granting, don't we give even that much more discretion to the trial judge?
Your Honor, as I understand it, the review standard of this court is higher. And what, Your Honors, am I answering the question correctly?
Yeah, I think that what Judge Wallace was shooting at was that our standard of review is gross abuse of discretion or something close to that, although I'm not sure I understand the difference between gross abuse and regular old abuse, but be that as it may.
Yes. Well, Your Honor, as I understand it, what Your Honors are dealing with is the reasonable person standard. And if reasonable people could disagree, then Your Honors should uphold the verdict. However, I would respectfully submit that where the facts are objectively wrong that are set forth in the order, then reasonable people could not disagree. For example, if there is a finding in a new trial order that based upon the facts that the car was red, and accordingly there should be a new trial, and the facts undeniably prove that the car was green, then Your Honor should find that reasonable people should not agree or could not agree on what the trial court found.
Can we
Obviously,
focus on the, I believe, which is the back and forth between the judge and you and the witnesses in the trial on the subject of letters of protection? You would agree that that's probably the central focus of this appeal. Is that correct?
I believe that's correct, Your Honor.
Okay. Do you think it was pretty clear and made pretty clear by the trial judge that you were not permitted to insinuate that the plaintiff's lawyer was the antagonist or originated the letters of protection? Is that correct?
No, Your Honor. I do not agree with that.
You do not agree with that direction from the court?
I do not, and I'll explain why. If you go through the first day of the, first of all, there is no written order on any motion in limine, so we can set that aside. Secondly, Your Honors, if you go through the first day of the trial transcript, there are specific motions that the court goes through, and none of those addressed the letter of protection. The only time that the court ultimately addressed the letters of protection in the case was when we went through, on that first couple of days, was when we went through the transcript of Dr. Newton. And in that case, the judge eliminated one set of questions or one question about the letter of protection to Dr. Newton, which essentially was that, and it's set forth in the brief, that Dr. Newton was letting the plaintiff's attorneys know that he was going to be looking to the attorneys to honor the letter of protection, which in fact, Your Honors, they ultimately did. Now, Judge Wallace, I know what you're referencing there, and that is the actual exchange with the trial judge at the time of the letter of protection question. Now, what's important, Your Honor, about that is if you look at the LOP question, and by the way, there is one question that could be, and I would respectfully say, misinterpreted to imply that the plaintiff's attorneys prepared the letter of protection for Dr. Newton. And that question is outlined in the record citation is in the brief, in both briefs. The question was, the preliminary questions were that, these are questions to the plaintiff during trial. You went back to see Dr. Newton, the chiropractor that had seen you 41 times in the 2 years before the accident, and she says, of course, yes. And the question is this specifically. Question, and at that time, you had a letter of protection for your attorneys, Mr. and Ms. Faddis, with Dr. Newton, right? So, Your Honors, that question may be somewhat ambiguous, but the intent of the question was that the plaintiff had a letter of protection that her attorneys were going to honor out of the proceeds of the lawsuit. And in fact, if you look at Dr. Newton's deposition that was read at trial and the testimony of Dr. Newton that was read at trial, he affirms that. He states that yes, he was going to be paid out of the proceeds of the litigation. So that was the point of this, is that the plaintiff's attorneys were indeed going to honor the letter of protection with Dr. Newton, which in fact the record shows that they did. So certainly that question, especially in light of all of the other testimony about the LOPs. And Your Honors, if you look at the testimony, and I know Your Honors have, from Dr. Mountain that was read at trial, I'm sorry, not Dr. Mountain, Dr. Mountain's representative. If you look at the testimony from Dr. Cuff, there were many questions about the letters of protection. If you look at the record evidence and the deposition of Dr. Newton that was read at trial, there are multiple questions about the letters of protection. The letters of protection were admitted at trial. The letters surrounding the letters of protection were admitted at trial, where there were letters from, or at least there was one letter from plaintiff's counsel to the doctors about the letters of protection. So there are 2 points to be made about that. Number one, Your Honors, absolutely the record shows that I did not violate any orders in limine. I believe that is 100% clear. And in fact, Your Honors, I believe that the appellee has conceded to that by implication because the appellee could not point to any orders that were violated. Not one. And so, Your Honor, that fact that is set forth in the trial court's order is objectively incorrect. And where that is objectively incorrect, respectfully, no two reasonable people could disagree that that was a factually incorrect and a wrong basis upon which to grant a new trial. So There's 3 points about that I think I've made. First, there was not an order that ever precluded or limited the use of the letter of protection in any way. And in fact, Your Honor, when you look at that exchange, and I know that has been highlighted in the briefs, if you look at that exchange on that one question, by the way, that's the only question that is ever raised on that LOP issue in any of the briefs, because that was really the only question to the plaintiff that was ever dealt with. And the plaintiff's attorney at that time specifically argued that I had, and this is the quote, violated the motion in limine that was denied without prejudice. So if there had been an order on that, certainly that order would have been cited. And you can see throughout the course of the motions that the plaintiff filed below, and throughout the course of the proceedings below, where there were the arguments on the motions for mistrial, there was never one time any particular order that was cited as being violated. So, Your Honor, did I address Your Honor's question?
I don't have any other questions.
Okay, all right. So, yes, Your Honor, there specifically was not any direction on that, not to link the plaintiff's attorneys. And part 2 of that was because there were no orders on that, there was no discussion of that until that question, in fact, of the plaintiff in cross-examination. And secondly, Your Honor, if you look at the question as stated, I don't believe, respectfully, that it links the plaintiff's attorneys or shows that the plaintiff's attorneys or implies that the plaintiff's attorneys were the origins of that letter. In fact, I believe the correct interpretation of that was as it was intended, that the plaintiff's attorneys were going to honor that letter of protection. Judge, there is a case that is remarkably similar to this. But to back up, Rule 1.530, of course, requires that the trial court, in all orders granting a new trial, must specify the grounds for that new trial. And when those grounds are wrong, that must be, as a matter of fact, a basis for reversal. Now, the reason is this. Due process requires that the trial judge set forth specific reasons so that those reasons can be given proper review. If the trial court's not required to give specific reasons, then we are left with that situation that the Lasky court said is improper, is that the trial court is essentially sitting as a 7th juror, in this case with no oversight and absolute authority to reverse a trial for any reason stated or unstated, or just a feeling.
What about the trial court's finding that there was continuous acrimony between counsel and that disrupted the flow of the trial?
And again, Your Honor, there's 2 points to make about that. Number one, a careful review of the record does not show that. Okay, it does not show that. There certainly was, there were the motions that the plaintiff filed during the course of the trial, and I think Your Honors can read those motions and certainly gather the personal attacks that were made there in the tenor of those motions. None of our responses to any of that, nothing that we said at trial ever approached anything regarding that. And none of the defense's motions or none of the defense's statements at trial ever made any accusations, ever commented upon the veracity of plaintiff's counsel, anything of that nature. And in fact, I would say that not only that, but the statements that the plaintiff's counsel made at trial were also outside the hearing of the jury. So none of that was ever before the jury.
Well, except during the rebuttal closing argument, didn't plaintiff's counsel accuse you of trying to accuse them of insurance fraud, whereupon you moved for mistrial?
That's exactly correct, Your Honor. And I felt obliged to do so based upon how it was, how that statement was provided to the jury. Absolutely, I did. The judge denied the motion for mistrial at that time, and in fact, as Your Honor obviously knows, instructed the jury and gave a curative instruction at the time.
How many other times did the trial judge entertain motions for mistrial from either party?
I know that there were continual motions by plaintiff's counsel throughout trial. I would not be able to answer that question accurately, Your Honor. I know there were several motions throughout trial. As I recall, there was one, of course, when plaintiff's counsel approached the bench regarding the questions about the letter of protection, there was a motion for mistrial. He made that motion twice at that time, I believe. There may have been another motion for mistrial during the questioning about Mountain Medical. And then, Your Honor, there was, of course, one morning when we were presented with a motion for mistrial in writing where that was addressed. And certainly we responded strongly to that at that point.
How many times did you move for mistrial?
I believe the only time I moved for mistrial, Your Honor, I believe that was in, I don't want to say it was absolute certainty because I would have to review that again. I did not focus on that at all, but in my preparation for today. But I believe, Your Honor, that the only time we moved for a mistrial was at closing.
The
I
trial
believe that to
judge
be the
in her
case.
motion writes, "The court admonished defense counsel numerous times to no avail. Defense counsel continued to insinuate collusion between plaintiff's counsel and the treating physician on the basis of the LOP. Defense counsel improper comments likely affected the jury's perception of plaintiff's retention of counsel. Indeed, such improper suggestions were made. The jury submitted a question regarding the timing of plaintiff's counsel's retention." Is that the finding that you think is objectively unreasonable?
It's not only objectively unreasonable, it's objectively wrong. It's objectively wrong, Your Honor, from a review of the record. Your Honors can see, and Your Honor, there was one case that we cited where the court said, we reviewed these records specifically for these types of things. And I would absolutely encourage Your Honors, and I know that Your Honors have and will continue to review these, but the only time that there was any mention, or not even any mention, but any statement that could be misinterpreted as linking plaintiff's counsel to the LOP was this one particular question that is called the LOP question in the briefs. That's the only time. So, of course, there were arguments about the letters of protection with respect to the interest that the medical providers had in those letters of protection. Certainly, that was an argument that we made to show the bias of the medical providers, the chiropractor and Mountain Medical. And you may recall that Mountain Medical was the entity that treated only patients who were represented by attorneys and treated only patients who were involved in some type of accident. So certainly that information is available to use to impeach the credibility of those doctors in those cases. So the other part of that, Your Honor, that you can see is objectively wrong, is the issue of that somehow spurring the jury to ask the question, about when plaintiff's counsel was retained. Please look at the questioning in the direct examination of the plaintiff. There was twice where plaintiff's counsel asked his own client, when did you retain us? Plaintiff's counsel asked that. Plaintiff's counsel brought that to the attention of the jury, not the defense. So to draw the conclusion, and again, Judge, this shows how that order is objectively wrong. When the judge draws a conclusion that the jury asked that question because of this one LOP question, which is the one LOP question during the entire course of the plaintiff's cross-examination, except where I came back and said, you signed this document right after there was the colloquy at the bench that Your Honors have recognized. But to draw the conclusion that the jury asked that question because of the LOP question, Your Honors, you have to take that into context with the plaintiff's attorney asking her in direct when she retained him. I see that I'm into my rebuttal time, Your Honor.
Thank you, counsel.
May it please the court?
Yes, sir.
Good morning, Your Honors. Appellate co-counsel Nick Shaneen sends his regards. I think he's up to his knee in recounts in Orange County this morning. This is the first time that I've ever conducted an oral argument in my career. I usually have a policy to allow appellate counsel, the experts, weigh in, and I appreciate the opportunity to address you this morning. The first thing I wanted to say in response to Mr. Goebel's appeal and arguments this morning is that the week before trial, we started to understand that we were going to have
Is that
to,
in the record?
pardon?
Is what happened a week before trial in the record?
Your Honor, the portions of that are in the record because the week before trial, we were knee-deep in doing video depositions and then designations and objections and that kind of thing. But on the first day of trial, before we began, I made an oral motion in limine to address what we perceived starting the week before, that we would have to try a fraud defense, an unpled fraud defense, which we had no opportunity to address in pretrial motions, nor address in crafting a rebuttal to that fraud defense. But we thought that it was coming, and that was the reason why we alerted Judge Tharp to the possibility. At that time, it was only a possibility, it was a premonition, that Mr. Goebel intended to try a fraud defense. Now, if you read the closing arguments, what I told Judge Tharp on the first day of trial before we began was strikingly accurate. The premonition that I had the week before, starting the week before, was accurate if you read the closing argument. So if you read the closing argument and you understand that not only did we have to try an unpled fraud defense and get deprived of the opportunity to address it and develop a defense, but at the time that he was developing the fraud defense, in the run-up to the trial, he was using our paralegal that he had hired without notice to us.
Well, that's not an issue on appeal, though, right?
Your Honor, it is part of Judge Tharp's order at paragraph 3.
Well, I understand, and I understand that, you moved to disqualify them. The trial judge denied it, and that isn't an issue. You have cross-appealed that issue. So although we understand the historical fact that they hired your paralegal away, who had worked on this case, that's not an issue on appeal.
Your Honor, I defer to the appellate counsel on that matter, and
We're the appellate counsel today.
Mr. I'm sorry.
You get to defer.
I've only been appellate counsel for about 24 hours. But yes, it is true, Judge Orfinger, that appellate counsel, for whatever reasons, decided to make the points that he made in the brief. I would have done it differently, but that's because I'm not an appellate counsel and I defer to the expertise of Mr. Shaneen. So yes, you're correct on that. But the point that those two things have in this case, I think it's important to go back and step away just for a moment. I think the underlying current in this case is how a lawyer could get away with doing what he did with us. When I had the premonition on the first day of trial, I said, he is going to try a fraud defense. That's what I'm getting the feeling of. That was part of the motion in limine that she addressed. Now, Judge Tharp denied it because she said, I haven't heard enough yet. I'm not sure about that. I don't believe that he's going to do it because the rules require you to plead it before you do it. And so she denied it.
What was your argument? I mean, what's your basis to say that simply inquiring about a letter of protection equates to a fraud defense?
Well, it's not just the letter of protection, and I understand that the law allows letters of protection to come in. We purposely, my law partner, who's here today, Tiffany Faddis, and I purposely had a policy not to execute letters of protection, not to tie the lawyers in to the collusion that otherwise came out in this case between the doctors and the lying client. Of course, Mr. Goebel on several occasions called our client a liar and then called the treating physicians liars because they were going to get paid at the end of the day, and they would come in and say anything to establish the right to the personal injury recovery, which he then tied us into it. When we were arguing at the very beginning about the potential fraud collusion idea, insinuation, we specifically thought that Mr. Goebel, by his questioning the week before, was going to tie us to that letter of protection. And we did not want to be tied to that letter of protection. In fact, we did not sign it. We stayed away from that. And what Mr. Goebel was doing by his questions, which Judge Tharp had the unique opportunity to know what the inflection was, to know how he was answering the question, where he was highlighting the questions about the letter of protection and our involvement in it. We did not want that to occur, and that was what she addressed, Judge
Counsel,
Tharp.
how many, if I'm not mistaken, and I've gone through the record and the transcript, there was one question asked in front of the jury about letter of protection, and it said, for your attorneys, not from your attorneys, not signed by your attorneys, and I agree with what Mr. Goebel said and probably what you would say. That's kind of ambiguous as to whatever it meant. It's kind of tying your firm to it somehow.
Yes.
Other than that one question, was there any question or any evidence offered that tied you or your partner or your law firm to a letter of protection in front of the jury?
I believe there were a couple other, I can't refer you to the portion of the record, but I think there were a couple of times that we felt that we were being tied to that letter of protection, other than that one question. I think there are...
I know there were other instances where there were mentions of referrals or who sent you there or whatever, but in terms of the letter of protection, the only time I saw it was the one question in front of the jury, and that said, the letter of protection for your attorneys, and after that, I don't see it anywhere else.
I apologize. I can't answer that question with any definitive certainty. I think there were other portions of the trial that I could go back and look at and pull, but I don't have those citations right at the moment. I apologize.
It's all right.
But anyway, Your Honors, the bottom line here is that just on the basis of paragraph 3 in the judge's order, and whether or not she was in that unique position to know, that addresses the involvement of Mr. Goebel in hiring our paralegal. Now, I know it's not in the briefs or whatnot, but the fact is that had we been noticed, and we believe that there is a notice requirement under our guidelines, the guidelines that govern lawyers and the ethics and professionalism that are called for us to abide by, that those guidelines, when a presumption is raised that there's a conflict and there's a disqualification, if the law, and there's a 5th DCA case that's...
Counsel, I know you want to argue about the fact that the judge denied your motion to disqualify, but it's relevant only to the extent that she put in her order that that was a factor that she considered. But the merits of her ruling, as far as the disqualification motion, aren't an issue on appeal. So I don't know that you need to waste your time beating on that too much, whether she should have disqualified him or shouldn't. She didn't. You haven't appealed it, so that's where we are.
Yes, I apologize for getting into that. That was something that was dear to my heart.
I know it grinds you. I mean, we get that, but that isn't an issue that we can help you with.
Okay.
Mr. Faddis, how many times did you move for mistrial during the trial?
I think 8 times, I believe.
How many times did Mr. Goebel move for mistrial?
I think he moved twice.
Okay, once in closing, and when was the other time?
Once, and I can't give you a citation, but I believe there is another time that he moved for mistrial, if I remember correctly.
What about the judge's finding as part of her granting the mistrial that there was a lot of acrimony in front of the jury, or that tainted the jury, as opposed to discussions at the bench? She's talking about in front of the jury. Can you shed some light on that from the record?
I would agree to some extent with Mr. Goebel's characterization that a lot of the acrimony that was described by the court occurred outside the presence of the jury. We attempted to keep those matters from the jury, and I think that we were somewhat successful in doing that. However, I can point to one of the things in the rebuttal closing argument I think that you referred to earlier, when I digested the fact that my law partner and myself were tied into this insinuation of collusion and fraud, that I had to address that before the jury, and I certainly did that in the rebuttal argument, and the exchange between the objection you could call acrimony by Mr. Goebel. So to the extent that that occurred, there was this acrimony before the jury, and I think the judge was accurate in describing that. And I was prevented from going into, in more detail, the accusations and defending my law partner and myself by the judge's sustaining of the objection.
In front of the jury, who ever said fraud or insurance fraud?
I was the only one that said insurance fraud. I think there's a reference in the order, or there's a reference in an exchange in the record where the judge told Mr. Goebel that he had walked the line really tight, and that's where he made his mistake, insinuating. There's a long line of cases that prohibit the insinuation of fraud because of the effects that such insinuation would have on not only the attorneys but the legal profession themselves. Can you imagine lawyers being accused of collusion in front of a jury and that being allowed? That could never happen. Now, it could happen under one circumstance. If the defense pled a fraud defense, and which they are certainly entitled to do under the rules, but if they had pled a fraud defense and given time, manner, and scope and allowed us to address it, if there was indeed fraud, if there was fraud as a plaintiff's lawyer and I'm on notice of it, I'm not going to try a case and try a fraud case. I'm going to get the hell out. But we never had that opportunity, and.
At what point does raising financial bias go to the extreme that it becomes a claim of fraud?
Read the closing argument. And during the trial, read some of the exchanges and read some of the questions. Mr. Goebel called our client a liar and claimed she gave false testimony, and then tied that to the doctors giving false testimony, saying and doing anything to get this personal injury recovery so the personal injury clinics could get paid, so that the personal injury lawyers could get paid also. I think when you tie that up, you look at the closing argument, you tie all those together, and what do you come up with? You don't just come up with an LOP and a financial interest of a doctor. You've got a lying plaintiff, you've got lying doctors, and you've got lawyers that'll say and do anything to obtain a personal injury recovery. I think this is the case that stands out from all others, and it's an important case to make that recognition and make the recognition that lawyers cannot get away with or breaking the rules. That's what happened in this case. Mr. Goebel intended to try a fraud case. He hired our paralegal out from underneath us without giving us notice. Then he tried the fraud case and is trying to get away with it here today. Judge Tharp saw through that and ordered a mistrial. And we ask you to affirm the ruling, and I'll sit down if there's no other questions from you.
Thank you, counsel.
Your Honors, I see that I have
Mr.
three.
Goebel, your reference to the plaintiff lying, was that made in the presence of the jury?
Not only was it not made in the presence of the jury, it was never made. That was the first point I was going to address. The record that we've provided to Your Honor, I believe, is in PDF searchable format. Search that word liar. See if I ever stated that. It never happened. And that is the type of thing that we had to deal with during trial, is this type of accusation. Judge, the second thing that the appellee has consistently raised is this issue of a quote-unquote fraud defense. First of all, the trial judge rejected that. She denied the motion for mistrial based upon fraud. And in fact, in the order that was entered, there is no mention of that whatsoever. So that issue is not even an issue before this court. I think, Your Honor, Judge Edwards, you hit the nail on the head. What we were dealing with was the financial bias of the medical providers. And certainly that is always an issue for the jury. The issue for the jury of the financial bias of the defense experts was before the jury. And certainly the financial bias of the plaintiff's experts and treating providers was also before the jury. But Your Honors will see, not one time during the course of this trial did I ever call anybody a liar. Never. Your Honors, this issue of the trial court having a unique position, I think Your Honors have now heard that there was no animosity or any of this issue that the trial judge had a concern about in her order that was before the jury. Counsel has now agreed to that, and Your Honors can see that. So I think that issue should be set aside. So what we're back to then, and Your Honor, Judge Wallace, you asked me how many times I'd moved from mistrial at trial. I recall the one time at closing because I read that portion of the transcript last night. I do not recall another time. The record will speak to itself for itself on that. Of course, I would defer to that. I just don't recall another time. So the last point that we're dealing with then is this issue, this objective issue regarding the letter of protection question. That objective issue. And the plaintiff has said, and in their brief has stated that a cold transcript or a review of a quote-unquote cold transcript does not need to support the motion for a new trial. I would respectfully disagree. I think there must be some evidence in the record from which the court can draw the conclusions that the trial court drew. This case, I believe, Your Honors, is remarkably like the Padilla case that we cited in our brief, where that trial court lost sight of what the orders in limine were. That trial judge granted a new trial based upon a violation of orders in limine that did not happen. Respectfully, Your Honors, that is the situation here. That's why we believe that there should be a reversal in this case.
Thank you, counsel. All right, thank you both. We'll move on to the next